over to, thank you. Before I turn it over to Kareem and Nora, Yasmin, I see you've had your hand up since we started. Is there a question you had to make sure you're in the right place or something?
Yes, hello.
Hi.
Thanks for the invite, but it says fathers only, and I'm a mother, so
It's okay. It is not
is that
fathers.
okay?
It is okay. It
Okay.
is okay. It is not fathers only. We are open to all. We're open to everybody. When we go, if we go into
Wonderful.
breakouts, Yasmin, if we go into breakouts, what we do when we have women on the call is we just leave you guys in the main room to give you space to have conversations in the main room that will be facilitated by Dara Griffin. Okay.
Okay.
You are more
Sounds
than welcome.
great. Thank you.
Thank you for joining us. So with that, I am going to turn it over to our content experts tonight, Kareem and Nora from Dad's Evoking Change.
I appreciate it, Kevin. Thank you. I appreciate everybody logging on today, sharing the space, sharing the time with us. You know, it's a Thursday evening. You guys can be doing a lot of different things. You're here with us, so we definitely want to give thanks and appreciate you guys. Big shout out to Dara, who came in with the DJing skills, this impeccable. Every Dad-scussions, I'm just like, can Dara just DJ for 5 more minutes? So shout out to Dara for the vibes and just entering this space and creating this some good energy for us to go into. My name is Kareem. Thank you, Kevin, for the introduction. My name is Kareem Chadley. I am the founder and executive director of organization Dad's Evoking Change. Dad's Evoking Change is a nonprofit which really its main purpose is to provide legal resources, information, community resources to fathers who are navigating through the child support and child custody systems. And so we have a lot of great programming. I actually want to highlight 3 of our programs, and I will be giving out the flyers to these programs as well, just because I think the information is pertinent to this group of folks. So we do hold free legal consultations. We have 2 different variations of the free legal consultation. One, drop-in, which we have drop-in hours once a week in the city of Oakland, California, where folks or fathers can come down, speak with a family law attorney, kind of get a game plan together as they're trying to navigate, you know, the various hurdles that come along with child support and child custody. We also have a virtual session of the free legal consultations, which is monthly, so once a month, and that's held over the free app Clubhouse. So it's the same situation. Fathers can log on, speak with a family law attorney, and get some help kind of navigating certain spaces as it pertains to the family law courts. And the last program I'll mention just really quickly so I don't take up too much time is our free co-parenting therapy. We pride ourselves to be an organization that works with fathers, but we like to also say that we are not anti-mother, we're pro-family. We like to host and hold programmings that will help the family unit as a whole. So our free co-parenting sessions are held virtually also. Those are on Thursdays from 6 to 8. And I'm gonna drop the website where folks can go to apply for their free sessions, which is on our website, dadsevokingchange.org. Once again, the 2 free legal consultations are dropping in the virtual, as well as our free co-parenting counseling that's held virtually at this point. So without further ado, today we're going to be covering some great topics. I'm sure that all of you guys that work with fathers, or if you're fathers yourself, always get questions about what to do when a father is dealing with a situation where their custody visitations are not being followed. They may or may not have an order from the courts that is not being followed, or they may have a verbal agreement with the co-parent of their children that's not being followed, and what do folks do? So today we are going to be Nora Al-Yami, who is a family law attorney, a former board member of our organization, Dad's Evoking Change. She's an attorney at law, the rising 2021 and 2022 lawyer in Alameda County. She has also founded her own company, DIY Family Law, which I'll be leaving the link to her organization as well. Nora is going to come on today and really take us through some steps about what fathers can do when they're dealing with violations of a custody order or a visitation order. So with no further ado, Nora Al-Yami.
Thank you, thank you. Good evening, everyone. Can you hear me okay? All right. Yes, thank you everyone for being here this evening. My name is Nora Alyami and I am an attorney here in the state of California. I'm located in West Oakland and I have a business. It's a consulting practice for the most part, but my goal is to educate and empower folks who are self-represented litigants in family court. And what's special about this is that I do unbundled services, which means you can talk to me for an hour or you can talk to me for 5 hours. But it's really up to you how much information, how much help. I can ghostwrite things for you. I can appear for you. So check me out, DIY Family Law. I'm here in Oakland. Most counties all over the state are still doing virtual stuff. So I can help you probably no matter where you're at. But yes, so without further ado, we are going to jump in. If everybody, can you guys see my screen? Thanks. Okay, so tonight we are talking about dealing with violations of custody and visitation orders. Again, here's my name, here's my organization. My contact information will be throughout the presentation tonight. So yes, I'm an attorney. It is called a Super Lawyer Rising Star 2021 and 2022. Basically, that's just a fancy name for saying that people think I'm a good lawyer and like the metrics prove it, I guess. Yeah, so in the pandemic, I founded DIY Family Law, which again is tailored to assisting self-represented litigants. I'm a former board member of Dad's Evoking Change. Again, there's my contact info. We're gonna get through this part. Okay, so this is specifically what are we gonna get into tonight? What is a visitation schedule and how to go about getting one? You can do it by party agreement, family court services, mediation, and then the judge makes an order, or you can have a whole trial and then the judge is just going to issue orders. And we'll talk about each of those a little bit more momentarily. And then once you have an order, what does it say? What does it mean? And then what is compliance versus what is a violation? So we're all here because we want to learn. What do we do when the other party's not doing what they're supposed to do? Well, we're going to get to that, but let's lay a little groundwork first. And then how to respond to a violation by your co-parent. And I have it right there in this outline is document. This is going to be what you're going to learn today, what to document, how to document, get your receipts, keep your receipts so you have them to take to court. And yes, what and how to tell the court about these violations that you're alleging. So that's kind of the nutshell overview of what we're going to be looking at today. Again, Kareem is going to be monitoring the chat. If I'm going too fast or if there's something that's not clear, drop it in the chat. Kareem will stop me and we'll make sure everyone is following along and on the same page. All right, jumping in. What's a visitation schedule? So when parents aren't living together, the child needs a schedule to ensure they're having frequent and continuous contact with both parents. And so frequent and continuous contact is in quotes because that is language that the courts have come up with through years and years of case law and litigation. That frequent and continuous contact is what California wants. It's just kind of general public policy. So in the absence of child abuse, domestic violence, etc., both parents should be having frequent and continuous contact with their child. So yes, California policy generally promotes this idea. So sometimes families need help creating a schedule to make sure that this is happening. Common schedules for a 50-50 visitation arrangement would include a week on, week off, if you've heard of that, or maybe if you have older children, you may be utilizing this particular method. All that it means is that the child is with one parent for a week, 7 days, however you guys want to start it, Sunday to Sunday, Monday to Sunday, however you want to do it. And then it switches. So the child will then spend that same amount of time, a week's period of time with the other parent. And then the other example I have listed here is a 2-2-3 schedule. And what does that mean? A 2-2-3 visitation schedule is basically the numbers denote the days. So 2 days with one parent, and then you switch 2 days to the other parent, and then 3 days with that first parent. And then that system switches. So what ends up happening is a child is with parent, let's say mom, Monday, Tuesday, 2 days, and then with dad, Wednesday, Thursday, 2 days, and then back with mom, Friday, Saturday, Sunday, and then it'll alternate. So the weekends, the fun days, the Friday, Saturday, Sunday is alternating every week. So both parents have that time with their child in addition to just like the school week stuff. Okay, so those are 2 common types of schedules. All right.
Nora, can I ask a quick question?
You sure can.
What do fathers or parents need to have in place, not in order to be able to have a judgment of 50-50 or 2-2-3? Like, what do I need? What do I need? My own apartment? Do I need a car? What do I need to have in order to receive that judgment?
So really good question. Technically, you don't have to have your own place. You can be living with other family members. You don't have to own a vehicle. That would mess up a lot of people in their situations. So in terms of like assets or things you have to have, I mean, if your child's small enough, you have to have a safety restraint for the vehicle. I mean, the court is going to insist on that. The court is going to insist that the child has health insurance, at least from one parent. I'm not sure if I'm answering your question, but you have to be able to show that this frequent and continuous contact thing is in the best interest of your child. So you can do that by showing how much you're participating in your child's day-to-day life. Again, thinking about the difference between physical and legal custody, which I know we're not talking about that today, but you know, in terms of a visitation schedule, it relates to physical custody. Where is the child physically at any given time? So you want to show that physically you're doing pickups and drop-offs from school. Physically, you are at, you know, soccer practice in the afternoons. All of those sorts of things to show your presence and active participation. Those are the sorts of things the court's going to want to see for physical custody and a visitation schedule.
Yeah, I was in a, and I don't want to hijack this because you are, I want you, but I was in a meeting earlier this week, and it was brought up, and a really good point was made that in some cases when parents separate, there's one parent who may have a little bit more or be in a little bit better situation financially or have more family support or things like that. And I guess my question is, does that impact custody decisions? Yes.
I mean, absolutely. So when judges put on the black robe, it does not like take away, you know, who they are and how they see the world, right? So on a very, very simplistic scale, absolutely. If there's a huge disparity in access to resources, you know, the judge is going to make a note somewhere, you know, mentally, whether or not they mean to. Is it supposed to impact? No. Does it? Absolutely.
Yeah, that's what I was going to kind of, and great question, Kevin. That's what I was going to kind of piggyback on as well. Do you feel being in the courtroom as much as you are in the courtroom, do you feel like when you're in the courtroom, you have witnessed situations where one parent maybe has the room that the child has been living in when the couple was together, and then now they're divorced? So one parent has that room that the kid is used to being in and used to sleeping in. Have you seen those type of things play out into like custody decisions? And you kind of answered it just now, but.
Yeah, well, I'm thinking of an example of a dad that I helped. He's a local, he owns a restaurant here in Oakland. His wife is in the medical field. She's some kind of a physician. I don't remember what kind, but she makes a lot of money. He make money, but she make money. So he ended up being the parent that left their primary residence when the divorce happened. And their son is like 14. So why is he going to leave his mansion up off golf links to go stay with his dad in like a little 2-bedroom, you know, wherever? Like what young person do you know who's going to want to do that? So then what ends up happening is mom gets to come to court and say, well, the kid doesn't want to go to visits. and he's 14. He shouldn't have to go. And really, at that point, it's like, he's still a child. He doesn't really get a choice. You know, if there's not domestic violence and all this other stuff, like the court shouldn't be enabling that sort of behavior. But does it happen? Absolutely.
Thank you. Appreciate it. And also, if folks have questions, please add them to the chat. We will be addressing questions throughout this this conversation. So make sure that you guys are you're throwing your questions in the chat. Thanks, Nora.
Yep. Okay, back to the PowerPoints. How to obtain a visitation schedule. So I kind of foreshadowed this in the very beginning, that there are 3 main avenues that you can utilize to get your visitation schedule. So the first one is if the parties agree. I encourage dads all the time to consider, when you and your child's mom are getting along, why not just write something down and file it with the court? If y'all are on good terms, that is really a good time to try to memorialize and get a record of where the co-parenting and how the visitation and custody is looking before the courts have to get involved to make any kind of decision. So party agreement, if you can capture that, at least, you know, get it signed and notarized, have it in your pocket, that's great. So if you are entered into the family court system and custody and visitation is at issue, they're going to send you to family court services mediation. And in every county, it looks a little different, but if you're in California, I know some of us aren't, but if you're in California, it's mandatory that you're going to go see a family court services mediator. And what ends up happening is if the parties can reach agreements during their mediation appointment, that mediator captures and makes a record and then gives it to the judge. In some counties, they will allow the mediator to also give recommendations to the judge based on the conversation that they facilitate with the parties. To give recommendations of what they think the court order should be, because they were the one that sat and really had the time to speak with the parents and hear kind of both arguments. The judge really doesn't have requisite or enough time to make those sorts of connections with people and get to the information they really need. So everyone goes to family court services mediation. If you have agreements, those get captured. If the things that don't get agreed on, you're going to go to court, you're going to have a hearing. Sometimes there's a recommendation, sometimes there's not. Kareem, I see you're unmuting. There's a question.
Thank you, Nora. Yes, absolutely. So real quick from Jesse, he asked, at what age does a child have a say-so in when or where he spends his time or their time?
Yes, slippery slope, great question. This is constantly coming up in like case law and like an issue, right? Rule of thumb is around 13, 14, depending on, you know, the fact pattern, like what's happening with the family. The court has a variety of tools. They can have the child talk to one of the family court services mediators. They can have the child come in, you know, like on Zoom and have a private conversation with the judge one-on-one. So there's a variety of different things, but those are really only in extreme circumstances. I don't want to give the impression that that's a normal thing. It's really not. So
it's not normal for a child to be brought into court to give their say so on where they want to be. That's only in extreme cases.
Correct.
Okay. I have another question from Yasmin. How can we in current times say a child has no say in custody because he or she is a minor? They're still living being, their state of mind and emotion and opinion is just as valid as the parents. I guess you kind of addressed that.
Well, so what I would add in there is, you know, there are always problems because young people don't have a voice. They don't have an advocate. They don't have an attorney most of the time. Again, sometimes they're really, really extreme cases where minors counsel gets involved because there's just so much conflict that the court decides that there needs to be an attorney for this child. But in most cases, the only way to get the child's voice heard is through a neutral third party. So get your child into therapy. that's my number one recommendation always. And find a therapist that is willing to have correspondence with the court, because there's some therapists that really, they don't want to get involved with that. So make sure you find a therapist that up front is agreeable to write these kind of detailed reports and deal with attorneys and all this other stuff, because it's a lot. So make sure you find a therapist for your child that's willing to do that. And I can say for the state of California, we really try to make mental health services available for young people, whether it's through school or extracurriculars or, you know, nonprofit organizations. Like, that is something California does a little better than other places. So make sure, you know, cast a wide net if you're looking for a therapist to support your young person. Okay, Kareem is back on mute, so I'm gonna keep chugging along. Okay, so if you end up in court, you see a mediator, they're gonna write a report. It's gonna include your agreements, the things that are not agreed upon. They may write recommendations, they may not, just depends on what county you're in. But then you're gonna have a court hearing. So at that hearing, the judge is gonna make a decision. The court is likely going to, and mind you, I say court and judge interchangeably, so that may not be something people are aware of. So just, I realize I'm saying that. So when I say judge and court, it's the same thing. The judge will make a decision. So they're going to look at the recommendations and walk through them one by one and say, you know, Mom, do you agree that Dad should have visitation the first week of every month? And then Mom's going to say yes or no. And then Dad's going to say, yes, I want the first week of the month. And then they're going to item number 2 in the agreement or in the recommendation. And basically there's a whole conversation that happens. It's a hearing, because at the end, the judge is going to make a ruling, and the judge is going to say, well, I'm going to adopt the recommendation numbers 1, 2, and 3, and then I'm going to now modify numbers 4 and 5 based on arguments I've heard. This is what the order is going to be. Thanks, everybody. Get out of my courtroom. And so then that is the order of the court. And then the third way is if a hearing is just really too much conflict, likely there's 2 attorneys, or what's at stake is really high. So if there are allegations of domestic violence or child sexual abuse, or a move away out of state, if there's anything like big happening like that, it's going to get set for trial. So, you know, this is where it gets more and more expensive. If you get set for a trial, it's a lot of work, and there's a lot expected of you. So you really want to try to make agreements either with the other parent or through mediation, or if you have to have a hearing, you know, like an arguing, it's called a contested hearing, get it done the first time. Don't come back again and again for more hearings on it. Don't do it. That's how you start getting in the hole. Okay.
Those are great points, Nora. I have a real quick good question from Maria. She asked, how many types of child custody are there in California? Can you explain what it means to have full custody versus joint custody?
Yes. So if I understand what is being asked, types of custody, there's legal and physical custody. Those are the 2 types. So legal custody is in relationship to who makes legally binding decisions on behalf of the child. Those are things like, where does the child go to school? What therapist do they see? What doctor do they see? What medications, if they're on IEP, any of those sorts of decisions, that falls in the legal custody arena. Physical custody is more of what we're talking about tonight, which is the visitation schedule, which talks about physically, where is your child at any given time and which parent are they with? And so those are the 2 types. I know people say custody and just kind of throw it around loosely, but there are 2 different things. It's legal custody and physical custody. And then kind of the breakdown of how those work is that it can be sole to one parent, which means that parent has, if it's sole legal custody, all of the decision-making power. They don't have to check in with Dad if they need to change, or whichever the non-custodial parent, to change medical providers or to medication. You know, right now, whether or not kids are getting vaxxed is like a big contested thing. So we're seeing a lot of arguments about vaccinations. Those are the legal decisions. So if you have sole legal, you do all that without having to get consent from the other parent. If there is joint legal, it means you're supposed to come to an agreement. So both parents need to communicate with each other. Again, this is assuming that there's not issues or allegations of domestic violence. The parties are supposed to work together. And again, the standard that we use in California is what is in the best interest of the child. It is not what's convenient to the parent, or, you know, what the top ranked school is in your district. No, it's what's best for your specific child. And so that is what the court is looking at pretty much in everything they do, is what's in the best interest of the child when they're deciding who gets what type of custody and how much of it. Does that
Thanks,
answer
Nora.
that?
Yeah, and I kind of froze out for a second, but I wanted to make sure that Maria, that was the answer to Maria's question. We have another question real quick before we move on from Cap. Does a parent's mental and emotional state play a role in a parent's ability to get full custody?
It should. It should. That is one thing that the court is supposed to consider. Again, looking at the best interest of the child. What does that mean? We're doing a little mini vocabulary terminology lesson here, but they're talking about health, safety, and welfare. Three things: health, safety, welfare. If the one parent's mental health is in a place where they can't keep their child physically safe because they're making reckless decisions, you know, we see this also with folks who have any kind of like substance abuse or drug addiction issues, like because they aren't really present to make the right decisions for their child in their best interest. Health, safety, welfare. So if you can make the connection that whatever the other parent is going through is impacting the child's health, safety, and welfare, then it's probably not in that child's best interest to be under the custody of that parent.
And how can you let the judge know something like that? Like, how do you relay that information? How do you, paint that picture in the courtroom?
So the most common thing I encourage people to do, and the most highly, I guess, utilized tool is a motion. It's called a request for order. So a motion and request for order, those things mean the same thing. So you file a motion. It's on a form FL 300, request for order. And on that form, you're going to have to check a couple of boxes about, what is it that you're asking for? And so you have to decide if you're asking for a full change in custody or a change to the visitation schedule, or there's a box for other orders. And that's where you can put in, other parent be ordered to mental health counseling, other parent be ordered to AA meetings, substance abuse treatment, whatever it is, you can put that under the other request. So you can make that independently of asking for a change in custody or visitation, or simultaneously at the same time with that request.
Okay, that sounds good.
Shall I keep going?
Yes, we have a couple more questions, but I'm going to wait until the next set of slides.
Okay, yeah, because some of the stuff is on target and we'll kind of work around it. So Kareem, I trust your judgment when to interrupt me. Folks, if you aren't getting your question answered, yell at Kareem in the chat and he'll make sure it happens. Okay, so now you have a court order, whether it came from a trial or from a hearing that was based on the Family Court Services recommendation or report, or your agreement just is now in front of the court and has become an order. What does it say and what does it mean? Okay, this all ties in because we are interested in how to enforce an order, right? But if the order is not really clear, it's going to be hard to get enforced. So let's take a step back and talk about what your order needs to contain if it's really going to be enforceable. So the custody order should be clear where a child will reside primarily, how the child is splitting time between their parents, how birthdays are handled. That is a high point of conflict for a lot of people, how birthdays are handled, where the child's going to be during the holidays, any other foreseeable events like extracurricular activities, who's supporting soccer, who's supporting football, whatever the case is. And transportation needs to be addressed in your agreements or the orders, because it's great to have all these things happening, but if we don't know how the kid's getting anywhere, that's going to pose a problem, right? So again, we're just taking a step back briefly, because you want to make sure that your orders include all of these things. If your orders don't include these things, you're going to need at some point to get back to court and get some more details, because it's going to, again, it's hard for the court to enforce or a police officer to enforce if it comes to that, if the orders aren't easy to follow or understand. So yes, at the end here, if you are unclear on an order, it's important that you ask clarifying questions to be sure you are in compliance. So before you leave, the day that the judge is making the orders, the trial is over, or your time is up on the law and motion calendar. If you don't understand something, or the judge forgets something, like for example, holiday weekend coming up, and the judge forgets to say how the holiday is going to be addressed, if it's going to be observed and one parent gets a long weekend, or the regular Monday switch happens, all of these things, it helps for you to just have on your radar before you go into the court, because the judge is not going to remember every single thing. And especially if something's meaningful to you. If you celebrate a holiday that your ex doesn't, and it's meaningful to you and your family or your heritage, you want to make sure, Your Honor, I need my kid this day, and this date in honor of this celebration that, is meaningful. So yeah, sometimes if you're having problems, the more detailed the orders, the better, because that's what's going to get compliance in the future. Okay, so here we are. I keep saying compliance versus violation, right? So compliance is the orders are clear and people are doing exactly what the orders say. You are in compliance. If you are not doing what the orders say, or the other party is not doing what the orders say, you are in violation, or some people call it a breach. You are in a breach of the orders. So you may hear breach or violation. So the number one thing you're going to want to do, regardless of how you got your orders, is the first thing, you need to contact the other parent and document to them why you think what happened is a violation of the order. So, oh, is this moving on its own? Did this slide just change? I did not want it to do that. Okay, somebody tech savvy gonna have to tell me, what did I do wrong? I don't know.
I'm not sure. It just looked like it just looked like you maybe by accident hit the button, but
I hit something like, yeah, no, but I.
oh,
Okay.
did you start a slide? Did you start a slideshow? It will go through the slides automatically. I'm not sure if that's happening.
I didn't, whatever I clicked, I didn't mean to. So if there's not like a quick fix, I'm just gonna pause where I'm at. Okay.
Okay.
All right. So first thing you need to do is start collecting your documentation, creating a paper trail that a violation happened and that you attempted to, outside of court, outside of filing, resolve it like adults between yourselves. So that means you're gonna take the initiative to sit down and draft a text or an email or a talking parents, if you're on an app, whatever it is, and you're gonna say what happened, why you think it's a violation of the order, and then you're gonna ask them to do better in a nutshell. So let's walk through it. So writing a text or email to your co-parent about their behavior is a powerful tool that you can show the court if needed. So again, this is step one, that you're documenting that something went wrong. And you're documenting it by getting this paper trail started of correspondence between you and your co-parent. So this communication, when you're reaching out to your co-parent, needs to include the following: the date of the incident. So what day was the phone call missed? What day was the exchange late? What day did your child come to a visit without, medication? When did the violation of whatever the order happen? And contact information for both of the parties. So what happens sometimes is, particularly right now, people are moving a lot. People have been moving a lot with the pandemic. So if you know that some of the violations are based on the other parents commuting, like they're missing exchanges because they moved to Stanislaus and aren't coming to Oakland to do an exchange, make sure you slip somewhere in there the current contact information. And if you have reason to believe that the other party has moved, which again is really common right now, make sure you put that somewhere in your like email that you're like, I know you're now coming from Stanislaus. I know you're now driving from Turlock. I know you're now coming from wherever. But being late or missing the visit is not acceptable. You're violating the order, right? So yes, the date of the incident, contact information, a plain statement of why you believe the breach of order has occurred. You missed the call. You missed the visit. You were an hour late. My kid came without their homework.
Nora,
Kevin, I
are
see
you
you.
reading
Yes.
this? Are you reading this off of a slide? Because we're not seeing the slide that you're looking
I paused it because it was moving.
at. Oh, okay.
Okay. What do you see something now?
Yes, we see the compliance versus violation, what to do when things go
Perfect.
left slide. Yeah.
So if you skip down towards the bottom, this is the communication, whatever your email or your text message to your co-parent, this is exactly where we are. The date of the incident and contact information of both parties. A plain statement of what you think the breach or violation was. They didn't do X, Y, or Z. A reminder, again, this is something that you are planning to show the court, so you're not being rude, okay? But you're going to remind the other parent of what the court order says. The court order says on Saturdays, our exchange is at 10 a.m. at Fruitvale BART station, whatever it is. You're saying it factually, you're not doing it emotionally, okay? So a reminder of what the court order requires of him or her and a warning. So we're not doing it yet. We're just letting them know if this continues to be a problem, I will have to go back to court. Let's fix this so we don't have to go back to court. So what I'm asking you to do is do the exchange on time. Remember their homework, whatever it is. And then it's right here on the very, very bottom, but it says, you will escalate the issue back to family court if the problem is not resolved by a certain date. And what's important about setting a certain date is when you go back to court, these sorts of issues when one parent is violating can be really technical if they go down the line of court proceedings to what's called a contempt. And so you really have to be clear what the expectation was and what the dates were and what needs to change and by when, because that's what you're going to take to court to say, look, I gave my co-parent a chance to get on board and do better and follow the orders. And I even told them, I'm not going to go back to court this time, but this is kind of your freebie. And then they did it again. After I specifically said, please be on time for the Saturday exchanges. Kareem, I see you. Question.
No, not even that. I just want to, we do have a couple questions from Daniel and one from Yasmin that I'm going to wait until a couple more slides go past. But I did want you to emphasize, and I would like to emphasize the that email that you're telling them they're doing something wrong should really not be done with any haste, with any anger, with any like negative energy or down talking, because then what you're trying to do and strengthen your case will work completely against you once you show it to the judge, because you as a father, you as a man, right, there are already going to be, you know, certain biases maybe against you and things like that. So I just want to emphasize, like, you should absolutely, you know, let the co-parent know, but you should do it in a way that's very constructive and not negative in any way or form, because any little way, if you're talking smart or if you're typing all caps or, you know, any little thing, they're going to use that against you in court. And so everything that you're doing is kind of then kind of deconstructed. And now you're just dealing with, oh, this guy's aggressive, or this guy, you know, he's emotionally abusive, or he sends me threatening text messages, or however they'll paint it in court. But just make sure that you really are on the up and up when you send that text. You might want to take a few deep breaths, drink some water, meditate for a second, whatever you need to do to center yourself before you send that text. because any little thing in your emotional being, they're gonna pick up on that. So I just want to throw that in there while you're making this point about, you know, contacting the other parent. Be very cautious with that.
Have somebody read it for you.
Yes, facts.
So you know, to really seek out the emotions and eliminate it where possible.
Yes, and this is hard. Now we saying this like it's a walk in the park. I just want to extend myself. I know it's hard.
Yes.
We know it's hard. We deal with fathers constantly, every day, all day, who are going through these things. These things are hard. It's stressful. It's emotionally taxing. All of those things, right? But as much as you can keep that out of your communication, it's only going to work for you. The end result is you want to be in your kid's life more. You want to have that relationship and not have anyone else dictating that, right? So they always got to center yourself back to the mission and realize that, hey, I might have to bite my tongue. I can't say this how I want to say it, but I'm going to say it with all of the niceties and all of like good emotions and all that, because they will pick those little things out in court and make them huge things. So I just wanted to throw that in, Nora, as you cover this part.
However egregious the behavior may be. Like, I know we got dads who drive out to Merced to pick up their kids. And I know how upsetting that could be to get there and to not be on the road back with your kids and you and mom not show up or whatever. We get that. And we got to remember what we want the end result to be, because we know how we get treated when we go into a courtroom. So,
Nora, can you speak on what the response should be back? Like you send the dad sends the communication, he receives a communication back. Does it have to be an ongoing conversation, or with the documenting of the incident, the paper trail, can it stop there again to ensure that it does not become something more other than a documentation and an ask? What does a response have to be back to the other parent, if any?
It's going to depend, you know, on what the response was, right? If they are saying, you know, I need to modify something or other, I mean, that's going to probably require a response, right? Like, can we change the time? It's all super fact-based, so I can't kind of give you like a general answer, but in general, yeah, you short and sweet and to the point. And I think I said earlier, you are writing it knowing that likely it's going to be in front of the judge one day. So know who your audience really is.
That's a great point, Nora. And that's a great question as well, Nora. Very, very great question.
Yeah, I'm sorry, I don't have something more tangible. It's super fact specific in terms of what conversation.
But essentially, you just need to send the initial text saying, hey, this violation on Thursday, the September 22nd, it was violent. You didn't make the agreed upon meeting. I just want to put that up to you. Please, next week, do it again. And that could be it. Yep. She writes you back, oh, well, you always missing it. You don't have to respond to that. You've already got the fact out. Okay.
And perfect. Then, so if the next week, the same thing happens, then you're going to send a second email and say, look, you're pushing my hand now. I'm going to have to go to court if you're not going to follow the order. And then if they write something nasty back, you're really set. I mean, that should be enough. I mean, legally it is enough. So, but
definitely don't play into the negativity. Don't respond with any negativity back. Even if they start it first, don't respond with any negativity. If you feel you got to do that, just don't respond at all. I would say.
Something that we talk about frequently is like, what are your support systems for your mental and emotional health? Because the court is not compassionate in any kind of way.
They don't care. They don't care, so, essentially.
Get yourself a strong group, you know, of friends to support you at your church. Find a men's group, go to the gym, find a therapist. all of the things. Get yourself taken care of so you can show up kind of in your best light when you're dealing with this other co-parent and with the judge.
And I know that sounds hard. It might sound like really foo-foo, you know, to some, but I cannot stress this the most, because the court does not care about your feelings. They really don't. And people that have gone through this system or have even, you know, felt it a little bit, you can understand and probably agree with me that the court really isn't there to hear your feelings, and they're not going to care about your feelings. Matter of fact, if you come with your feelings too much, they're gonna shut you down, and they're gonna look at you like a troublemaker or somebody who's, you know, not agreeable. So I would really stress this point. I know we're making light of it, like, oh, just go to the gym and stuff. Whatever it is for you, it can look different for everybody, but it's a very important component of it, because going through this situation is a very soul-crushing experience for sure. And we and we are sympathizing with you on that. We know it's a soul-crushing experience. It's not fun or fair. But with that being said, it is going to be what it is. Unfortunately, we're not going to be able to change this thing overnight. What we can do is change how we react to it. So this part, I know it sounds a little bit like, you know, foo-foo land, but it's really important. If that means you got to talk to your boy before you get, you know, talk to him. If you know, your support system, whoever that is, you know, try to lean on them, because they're going to be an important factor in this journey. I'm sorry, Nora, go ahead.
No, sorry. Yeah, thank you. So yes, in summary, we are capturing the first incident as soon as it happens, even if it's just they were 20 or 30 minutes late. Don't be petty. Don't do 5 minutes and 10 minutes, but, you know, start, you know, writing these sorts of emails when the things happen. Document everything. The most sensible approach to enforcing a family court order is to record every infraction of the order committed by the other parent. This may help establish a pattern of behavior. So again, capturing the who, what, when, where, and how, why the order was violated. If you have
Real
to go
quick, sorry, Nora, real quick, we do have a question about how many violations is needed before you would want to like take it to court. Like, is there a certain specific number, like, okay, it's that 3 violations, let me go to court? No? Okay.
There's not a hard and fast rule, because, you know, 3 times being late is different than missing 3 exchanges, right? So
do you have any suggestions about that? Like, you know, if they miss an exchange, like, would a judge feel like it's petty if they miss 1 exchange and you go to court? They probably would say, okay, well, that's maybe a little, you're jumping the gun a little bit. Like, is there?
Yeah, I wouldn't do it
Would you
after
have-
1. That's why we're spending this whole time creating a record, basically, so you can have something to show the court when you go. You have, it's called demonstrable, like, evidence, right? Like, you're demonstrating all of your attempts to be in compliance with the court order, to maintain your position in your child's life. So yeah, it would definitely come across, I think, in a haste after one violation. But make sure you get your email, your text message, your talking parents, family wizard, whatever you're using, documented. So the other parents on notice, like, you're not happy with them, and you'll file if you have to.
And okay, thanks, Nora. Jesse wrote back. He's talking about 6 months with only 1 visit in between court hearings twice. So I'm guessing that's a specific to a situation that he's going through. But I think you kind of answered.
I don't know what the court order says. Is it supposed to be every weekend? Is it supposed to be 3 times a week? I mean, again, it's all very factually specific. I don't know if we probably won't have time at the end. We still have more slides to get through, but keep putting your questions in the chat and we'll get to as many of them as we can.
And remember, Dad's Evoke, Kareem and Nora, they have events that go on multiple times a month where you will have that, where you can have the opportunity to talk to Nora directly about your specific situation. So please make sure you visit their website so you can get signed up and take advantage of that, because I know a lot of dads have found that to be very, very useful.
Thanks, Kevin.
Okay, so yes, again, you're capturing, you're collecting your receipts, right? What's going on? If you have to go back to court, this can be some of the strongest evidence presented by you. Again, the judge does not want to hear he said, she said. They want to see receipts. So, you know, if you have your exchanges at a Starbucks, go in and get a bottle of water. Have a timestamped receipt showing that you were there. Whatever, you know, some people will do a TikTok. I'm here, excited to see my kid, because those are all like time-stamped, right? So yeah, document. Okay, so this is again now for yourself. If you know eventually you're going to be filing a motion, either, you know, to get enforcement of the current orders, or if you want to change the orders so this type of stuff isn't happening anymore. So you want to know when the current order was issued. So when was the time you were in court that the judge said your exchanges are going to be Saturday morning at 10 a.m.? Because it may not have been the last time you were in court. Sometimes you go to court and the child support changes, but the visitation doesn't change. Or sometimes you go to court and, you know, a child's doctor changes, but their health insurance doesn't change, right? So it's like every single hearing is different. You want to make sure that you know which date, which hearing it was that the judge issued the order that you are trying to get enforcement on. And what did that order say? So you want to be able to say, I have the order from December 2020 that says mom is supposed to drop my son off at 10 a.m. at Starbucks, wherever. And so then the next thing, so what actually happened? This is what the order said. What actually happened? I was at Starbucks at 10 a.m. receipt. There was no exchange. After that, I went home and I wrote my email to mom saying, hey, there is a court order and it says this, and you weren't there. And the next one is supposed to be here. So I'm confirming that that's going to happen. Otherwise, I may have to go back to court and file something, which I don't want to do. Let's figure it out.
Nora, can I ask a question about that? How much time does a parent have? Like if it's triggering and they need that time to be able to send an appropriate email or text, how much time do they have from that violation to the communication to the other parent that you know, just to demonstrate that the violation happened?
So what the court is going to say is the more instantaneous the email or the message is, the more credible it is. So if you take a week to write and say, I didn't see my son for my visit this weekend, the court's going to be like, well, you don't seem really pressed about it because a whole week went by and you didn't complain. So, you know, my rule of thumb would probably be within 24 hours. But that's just a rule of thumb. That is not case law or is statutorily recognized. But the more instantaneous, the better. Your message can be as brief as, hey, I'm at Starbucks right now. It's 10:20 a.m. on Saturday morning and you're not here. The court order from December of 2020 says 10 a.m. exchange at Starbucks and you're not here. The next exchange is supposed to be on this day at this time. Can you confirm that you're going to do it? Otherwise, we may have a problem and we may go back to court. I mean, you may just want to write that down and have it like written somewhere, and then you can just cut and paste it so you ain't even have to think about it. You know, you don't have to come up with the words in the moment when you're upset. It's actually kind of formulaic, like who, what, where, when, why, how, to just capture the facts. Again, just the facts, just the facts. Okay. So these are the things you're documenting for yourself. When you're going back to figure out when that order, the specific one, not just the last time you were in court, but the specific order you want enforced, when was that issued? What did it say? What actually happened? Get some receipts. When did it happen? And then any evidence to show the court your allegations. So yeah, the receipts from the Starbucks, photos, you know, that are timestamped, TikToks that are timestamped, whatever. Important, You need to follow the orders yourself if you're going to go to court and complain about the other parent. So don't be that parent that goes to court throwing mud, and then the other party has a whole bunch of receipts themselves about how you catted off on visiting or, you know, going to kids' soccer practice or whatever. So yes, that's that last one at the bottom where it says important. You need to follow your custody and child support orders down to the very last request. And even though it shouldn't, those things should not be interrelated. Again, the law doesn't care about how we feel. The court wants you to pay your child support order and it wants you to follow the custody order. It's more difficult to argue your point in front of a judge if you've been doing the same thing. So keep that in mind. Okay.
And also keep in mind, you know, that sometimes there's biases, you know, that we have to deal with as fathers. Sometimes there's people that are looking at us like, you know, we're not the upstanding father that we are. And so we know that exists. Keep that in mind. You know, this is the time where keeping that in mind and acting accordingly really, really matters. You know, because we can complain all day about how it's not fair, which we are agreeing with that statement. But now we're trying to arm ourselves and equip ourselves with the resources that we need to go in there and still get our point across, still be articulate, and still get to our desired goals of what we're trying to do.
Yep. Okay, we're rounding home here pretty quick. So this next one is if the violations of the orders are really serious. So, for example, if you think your child has been kidnapped, meaning the other parent has taken the child out of the county or out of the state, out of the country without your permission or consent, that is a violation of the court orders, and that's a huge deal. So these next things that I'm going to talk about are in cases like that, or if you're concerned that there's child abuse happening, if CPS has been contacted, this is taking things to a new level, right? So these are the more serious types of violations, how to address them. You call the police and have them enforce the order. So again, it's important. You need to have a copy of the order to show them. You don't get to just call the police and say, hey, my exchange is supposed to be 10 a.m. at Starbucks, you know, and they're not here. You need to actually show them the order. They're not just going to take your word for it. So that's the other benefit of knowing which court order you're trying to enforce and having a copy of it, so you can like show it to the officers.
Does it have to be a physical copy? Can it be digital?
You know, probably depend. I'm speaking to an audience of refined people, so let me refine my response to that question. It depends on what officer you get. So, you know, if your screen is able to show that there's like the stamp, the seal and the stamp of the courts and a judge's signature, it should be okay. Should.
That sounds to me like bring the hard copy.
Yeah, I was going to say, it sounds like that's.
If we're dependent on
that's
a friendly
that's
copy
the
show up.
surer way. That is the surer way.
Yes. And does it have to be the original, or can it be a copy
No.
of the original? Okay.
It can be a copy.
Okay.
And what else was I going to say? Yeah. So again, this is the difference between what the law says, but then actually how it operates in real life. So Noah, yes, a digital copy should be fine. And in reality, may not be fine. So just if you can have a hard copy. I mean, if you know you're going to the exchanges and there's a chance this could happen, I would just say take a hard copy.
Nora, what if there is no custody agreement in place? Does a parent have the right to leave the county or state with the child? There's no legal custody. We're separated. Mom's living with the kid over here. I see my son, you know, or whoever every couple of days, couple times a week. Got too expensive in California. We still don't have a custody agreement. I want to move to Texas. What can I do?
So those are several questions with several answers. In the interest of time, would you like to make that one question that is?
Does the parent, if a custody agreement is not in place, does a parent, either one, have the right to leave, to relocate?
Relocate out of state? No, they are supposed to file something. Okay. You can't, that's when you call number 3, contracted district attorney's office, because that's child abduction. Okay.
All right. Thank you.
Yeah. So again, depending on the severity of the situation, these are the options that you should consider. So one of them being, yeah, immediately call the police. You know, again, this is if your child calls you screaming, saying that they're getting, you know, whipped or whatever, that's when you call the police. Like, so you have to use some judgment in terms of, you know, is this what I call observe and report type of violations, or is this, we need to call the police, we need to call child abduction, you know, CPS, whatever. So yes, number 1, call the police, have them enforce the order. So sometimes this one makes the most sense if the exchange, if you're picking up the child from the other parent's house and the other parent is just pretending like they're not home, that kind of thing. That's when you can call the police and be like, look, this day, this time, clearly they're here, the car's in the driveway, and just help me. So if those sorts of violations continue, you have been observing and reporting, but you're going to file for a contempt hearing. Contempts are complicated. That's why there's a very large description under number 2. So contempt actions are for cases where a parent is intentionally violating the court's orders. So that is they're just sitting at home, not delivering the child for the exchange when they know it's an exchange day and that there's an active order in place, and they're just, you know, turning their nose up. And again, the more documented incidents you have is how you're going to get a contempt hearing. So contempts, I think I say, okay, well, let me just follow my slide. In a contempt case, you're asking the court to enforce the order and make a finding that the other parent willfully disobeyed the court order and basically should be punished. This is a complicated motion and it can have serious consequences for the other parents, even going to jail. So again, this is they're not complying with the orders whatsoever. We're concerned about, you know, the child's physical safety, welfare, those sorts of things. And again, it's more technical. So because it has these bigger consequences of potentially going to jail or paying large fines. So yes, number 3, particularly the abduction situation, which has gotten more and more prevalent since 2020. That's when you call the district attorney, which is the prosecutor's office in the state of California. It's organized by county. So you contact your local county prosecutor's office, find the child abduction unit. There's a whole specialized department. So that's, again, not an observe and report thing, but if you think your kid is moved out of state without your permission or consent, that's where you jump right to that step. So yes, and then number 4, which is kind of what we've been talking about, is just filing a request to modify. So you're going to ask that the exchange location be changed, updated, modified. Felt like saying exchange and change at the same time. Yeah, so you just need to be really clear that whatever your request is being based on and showing your evidence that this has been happening and that it's a pattern of behavior. And so the court needs to take action.
Real quick, Nora, we have a question that's right along these lines from Charlie. Thanks, Charlie, for the question. Basically, the question is, what about a weekend getaway to Reno on the parents' weekend with the child? Is there any stipulations on that?
So again, everyone's custody orders are different. So some parents have no travel restrictions in their orders and some parents don't. If your orders do not contain travel restrictions, and it's not against the rules, but as a courtesy, I always encourage parents to communicate if you're taking the child out of state or out of the county with, because if God forbid something were to happen and the parent doesn't know where their kid is or how to help or, how to respond, we don't want that situation. So even, if you don't have travel restrictions, you're in the clear, but I do highly advise you to communicate that with the other parent.
And by communicating, does that mean get permission?
No.
Can I just say, hey, I'm doing this? Okay.
Assuming that
told
it's
you-
joint custody, you don't need permission. You can just say, hey, I wanted to give you a heads up. We're going to be going, to Reno for the weekend. We plan on driving or being back by this day at this time in order to facilitate the exchange because I'm a responsible parent. If you have questions or concerns, my phone should be on.
And what if you just have visitations, you don't have joint custody?
Yeah, no, well then no. So that goes back to like the legal versus physical custody stuff. Your visitation has to be within the confines of what the visitation order says. And so if you're not a joint custodial parent, you really don't have the leeway or authority to take the child out of state.
So visitation is not considered, this is a weekend, that's joint custody. Visitate is, go ahead.
Yeah, so two different things. And it is weird because they intersect in different ways, right?
Yeah.
So custody means sole custody means one parent has it. Joint custody means both parents have it. But joint custody doesn't have to mean 50-50.
Right.
So it depends on both what the custody, what it says, who has joint or legal or sole or physical or those, and if the parent is trying to travel during their custodial time.
Okay.
I don't know if that made things more confusing or more helpful, but just you need to follow what's in your order. That's what you need to know.
Bottom line, got it. Okay.
Yeah.
And so I've just throw it out there that maybe if it's not in your order, that I would try to get that place in your order before you did it, rather than going, just taking, your kids out of state and then having to face those repercussions.
Yeah. Why I don't have reactions enabled. I can't react and give you like a high five right now on my screen. That's Dara. What happened? Why I don't have no, there's polls, but not reactions. Okay. I was gonna big up Kareem for that one. Yeah. Use the court. Yes. Okay. Someone has a thumbs up. Why? Anyway.
Maybe because you're sharing your screen.
Maybe I don't get to do both. Anyway.
Yeah, that's what it is. And then we had one more question I wanted to get to from Marlo. They asked, what if you've already been to mediation and the co-parent is in violation and there's documents of the violations, or the judge is basically ignoring the violations?
You're going to want to specifically file a request for order that is for enforcement. So you don't want to be there on any other issue besides enforcement. You don't want to be negotiating child support. You don't want to be modifying the schedule. You are calling the court's attention to the violations and asking for enforcement. So it needs to be its own specific thing.
And what form number is that?
It's the same form, FL 300, but you're going to click the other box. So you're not asking to modify and it has like custody or visitation or, child support. You're not going to check any of those, but there's one that says other. And you're going to write enforcement of visitation, custody orders, whatever it is.
Perfect. And I assume that would be the same to this question from Yasmin. When the other parent is not visiting the child that was set up with the court, how do you report that to the judge? I'm guessing that would be the same.
Yes.
Perfect.
And if you're not ready to file like a request for order and get a court date, you just kind of want to put it on the judge's radar, you can file a declaration, which is like a short essay. And just start sharing with the court what's happening. So then, a month or two later, when you do decide, all right, it's time to file, something needs to change, hopefully the judge will have already read your declaration and kind of have a foreshadowing of what's going on. So that's another way that you can kind of be proactive up front and set the framework for the judge to let them know something's not right before you come asking for something.
Yeah. I think a lot of these questions are coming from places because folks are in the middle of some contentious
Disputes. Yeah.
disputes. And, I appreciate that and acknowledge that. And I think ultimately as a program, the goal is to get it to a point where ideally courts don't have to get involved. Ideally, we can get along as parents and follow through with our job and role as parents. I just don't want to come across as though, we don't want the battle. You know what I mean? I understand that some of you guys are in it right now, so that's why these questions are what they are, and I respect that. I'm glad that Nora's here to answer them. Eventually, we want to get to the point, and hopefully it can for you guys that are on this call as well. We want to get to a point where we're doing what we say we're going to do. The other parent is doing what they say they're going to do. And the real focus is on the well-being of the child, not getting back at the other parent. And that's just the standpoint that the Father's Corps is coming from, with the understanding that I totally get that you guys are going through some stuff, and a lot of dads out there are, which is why we're having this conversation, which is why we invited Dads Evoking Change. So I just wanted to, I know the tone of the questions and the tone of the call tonight has been kind of tough because you guys are going through some tough stuff, and there are dads out there going through some tough stuff. But ideally we'd like to work to get to a point where we can function as a team, whether we're together or not. And I know that's a long journey, and I get it. That's it. I'll leave it at that.
No, for sure, Kevin. I want to piggyback because that's such an important point. And I think that, a lot of our focus is, what to do while we're in the heat of the battle. And it's important for fathers in specific because we don't have a lot of places that we can go get free resources about the battle. It seems like there's a lot of resources being given, but fathers aren't really on the receiving end of those a lot of the time. And so this is definitely a place. But with that being said, again, like I prefaced the conversation today, Dads Evoking Change is a pro-family organization. We really want families to be whole. And that can really only happen it happens at its best when two people can put together their hurt, their trauma, their pain, which is all valid. And I know some of you are at a point where you can't even see that happening. I understand you too, my brother. Trust me, I feel you. But what we just trying to say is that one day we are hoping, the goal is that through you being armed with the right resources and everything to be prepared for a battle, that one day you won't have to battle and that you guys can be on the same place, because ultimately your children will benefit the most when they have that love coming in from both sides, and the love is not tainted with like, oh, I'm going to keep this person away or I'm going to keep that person away. And I know a lot of times we're on the short end of the stick, so it feels like we have a chip on our shoulder just about the whole thing in general. Trust me, I fully understand. But what we want to just also always bring back into the conversation is we understand that to be true, that the children thrive the best. Our communities will thrive the best when we as parents can start getting on the same page as much as possible. Some journeys to that end goal will be harder than others, but that's why we do have things like the co-parenting therapy. It's free. Take advantage of it. You know what I mean? Even if you're on not speaking terms, email your co-parent, let them know that this is available to you, and that when they're ready, that you guys can embark on this journey to start the healing process. Because a lot of healing does need to be done, but we just know that children thrive after that healing is done and parents can become more whole. So I just want to add that on. Thank you for bringing that up, Kevin. Huge point.
Kids can get over divorce. They can get over separation. It's that toxic, never-ending battle between parents that scars kids and sticks with them the rest of their life. So anyway, I'll be quiet. Nora?
Yes.
Kareem?
Well, we're going to wrap up so then we have a little more time for questions and discussion. So this is just kind of a summary of what we've gone over this evening. You should know the court order is the law. A judge has made that order for you. It is specific for you. It is a law, and you can go to jail if you don't follow it. It doesn't happen frequently in family court, The most we hear about it is about child support, right? But it's the same thing. Judges can throw you in jail for not following their orders, or the other party. Be sure that you understand what is being ordered, and be in compliance with whatever is required of you. So again, coming back to this pointing the finger at the other parent, we are standing in our full integrity and showing up and being present and doing what we're supposed to do before we're turning around and pointing fingers at the next person. And that really is for the judge, because the judge, they're going to start losing interest in everything you're saying if they figure out that you're doing the same stuff the other parent is doing. Should your co-parent violate the court orders, take notes capturing the information. Contact them in writing and bring the incident to their attention by stating the facts, and ask for their cooperation with orders by a certain date. So again, I'm trying to give you the language that is neutral, the who, what, where, when, why, and how. Get it documented, get it sent to the other parent, you're putting them on notice. If they, again, fail to follow the court orders, you can contact the local police department for enforcement, document the incident, and file either a contempt action. Again, if this is one of these highly charged things that, you know, child is in danger or I'm completely being cut off and alienated, those are the contempt ones. Or you ask for the request to modify the custody arrangement or whatever the visitation schedule is. That's the nutshell. And that's me.
That is you, Nora. That's a great picture, by the way.
Thanks.
It looks just like you, actually.
I know, right? Not a
crazy.
catfish. Hi.
So again, this workshop was really all about trying to arm you with tools and resources that you can use if your custody order, your visitation order is not being followed. I know we covered a lot of different ranges of topic. I want to remind everybody that we have free legal consultations. You can work with a family law attorney for free. We have a virtual session. We have a drop-in hours in Oakland. I really encourage all the folks that really have a lot of their story that they didn't get to tell and they really have some more questions to try to engage with us, Dad's Evoking Change, on one of those programs. Like I said, there's a virtual for all those folks that are not in the immediate Bay Area, and then a physical space that we could have in Oakland that you can drop into if you prefer to, speak with somebody in person, get help with courtroom paperwork, et cetera. So please use this as a resource. I'm going to drop the chat in the link once again. And then we had a few more questions. A lot of them were kind of repeat, and then you kind of covered. Another one from Marlo was would the enforcement also comply with a contempt file that was denied? I'm guessing he tried to file a contempt of court, it was denied. I don't think that's going to be enforced, correct? Because it was denied.
Correct. But you have to figure out, was it denied on a technicality, or did you have a whole hearing or a trial and then it was denied? So again, contempts are really technical in nature in terms of how you write them, how you plead them to the court. So some attorneys don't even like to do them. So you need to figure out, was it rejected based on a technicality, or was it rejected actually based on a merit after you got to a hearing? Because it may not be that the judge actually isn't interested.
Okay. And then another thing that came up a few different times, I know we kind of covered about, going in, it's really up to your judgment how many violations need to happen before you go in. What if you go in, you present the violations, but nothing happens from there? What's the next step after that? Is there any specific things other than continue to write down the violations, try to file for another court date? Is there much more that you can do with that? Again,
it really depends. It's factually specific. If the judge made a finding, if you have a hearing and a trial or whatever, you bring in your evidence and your witnesses and the judge says, no, I don't think these were violations. That's very different than a judge just kind of being dismissive and passing in a hearing, if that makes sense. So you really need to pinpoint down to a specific hearing or a trial where the only thing you're going to be talking about is the other party's behavior.
Understood. One just came in, 1 second. Someone I call OPD first. Okay, so Charlie asked, so when I call OPD to enforce the order, it takes them upwards of 8 to 10 hours to respond. By that time, I no longer want to enforce and have my child forcefully removed from the home that late and being disturbed when they are sleeping. I guess that's not really
real.
a question.
No,
Yeah.
but that's real. So what you do is you get a copy of at least a documentation that you called into dispatch or like filed a report or asked for an officer, get some kind of documentation that that violation happened and that you did try to get, you know, assistance at the time. Collect those
Great.
receipts, observe and report.
Yes.
Yeah, and
yes.
we just want to we want to avoid calling the police at all costs, only because it is unsafe when you are a person of color and the police get involved. And I understand that things happen and the police do need to be involved. So again, let's do our best to collect the receipts, go through the process, which can be very, very long. And I'm talking years and years. We get that. I don't know where I'm going with this. I just know that calling the police on another brother or sister is sometimes can be deadly.
Yeah, absolutely, Kevin. I know where you're going with it. I think ultimately, you know, unfortunately, we find ourselves in situations sometimes where, you know, we're kind of put our back against the wall. Then there's other times where we can also remove ourselves from that situation if we're skillful and use the right tact, right? I always want to go back to like, you know, this journey of co-parenting and dealing with somebody that you might not really care for anymore is really tough. But at the end of the day, your child needs both of you guys, and you guys are stuck together for umpteenth amount of years anyway, maybe even forever, you know. So at the end of the day, while it's very hard and not always possible, you know, sometimes swallowing that pride, not having to have the last word, not even having to say when you feel wronged or hurt by something, a lot of it is swallowing your own, you know, your own pride sometimes. And that's terrible to even say out loud. But again, it's like sometimes the bigger picture, you have to just keep that bigger picture in mind. What's your end goal? It's to spend more time with your child. You fighting constantly and always having a turmoil with your co-parent is probably not the quickest way to that. With that said, I know we're at time. I really sincerely appreciate everybody joining today. I'm hoping that you guys found this helpful. Once again, please visit the website, dadsevokingchange.org. We have all the information about our free legal consultations, as well as our co-parenting counseling sessions. Nora's website is DIY.com. DIYfamily.law. All right, let me put it right now. Yeah, put it in the chat for everybody. You can definitely contact Nora as well. And Kevin, once again, thank you.